Welcome to the Fletcher lunch and discussion with the Compromis Authors. And I would like to extend a special thanks to the Fletcher School of Law for sponsoring this event and for being an incredible support of the Jessup competition. We are so grateful to them. I'm very happy to be welcoming the Compromis Authors here today for you to meet and grill for the first time. And I also just want to extend a special thank you to Simone Kang of Fletcher. She has been an absolute pleasure to work with and get to know, and so we're just very grateful for her involvement with this event. So without further ado, I'm going to turn things over to Simone Kang, and please enjoy today's discussion.
Leslie, thank you so much. It's truly a pleasure for the Fletcher School to continue to be able to sponsor the final round lunch with the Compromis Authors. As a former Jessup competitor myself many, many years ago, I really would have appreciated the opportunity to ask the kinds of questions that I had been thinking about at 3 o'clock in the morning, dragging cases down on Westlaw and debating with my colleagues. And after all these years, I, as one of your students, have had the opportunity to help organize this event through my work at the Fletcher School to make this possible for you. The Fletcher School of Law and Diplomacy is actually the oldest school of law and diplomacy in the United States and specializes in multidisciplinary studies. So the purpose of the mission of the Fletcher School is to recognize the fact that the letter of the law is in and of itself one factor among many others that either foster or implement the facilitation of international law globally. And so in recognition of that, the Fletcher School also offers courses in diplomacy, economics and business, and security studies in a number of different areas which really help inform an international legal practitioner, because we recognize that a traditional law school education alone is no longer sufficient to prepare you globally in the coming years. So we hope that you will look at our website and also take advantage of our alumni that are here today and ask questions and reach out to us. We offer the LLM in International Law to specifically address these important issues. In addition to that, I know many of you are concerned in this economic climate about issues of scholarship and the opportunities and career opportunities available to you, and we work very hard to bring the best and the brightest. Clearly, we recognize that your work here at the Jessup brings a special recommendation to us when we review our very highly competitive applications. So I want you to know that we view you in a very special way. Our school is advised by internationally renowned faculty, so I have the pleasure today of introducing to you Professor Louis Aucoin. Professor Aucoin is our professor of practice at Fletcher and is also the academic director of the LLM program. And Professor Aucoin has been on the ground not only as a professor but also a practitioner, and he has worked for rule of law in Timor-Leste, Haiti, Cambodia, Rwanda, Kosovo, and most recently as the Deputy Special Representative to the Secretary General for Rule of Law in Liberia. I also, we'll be hearing from him in a few moments. I also would like to introduce to you your Compromis authors, Quang, Trinh, and Wong, who will be speaking to us and making themselves available to answer any questions that you have. We also have questions that have come globally, which we will be also interspersing. There are 2 microphones in the back of the room, so later on when you have questions, please feel free to come to the mic and ask them. And we also have sign-up sheets for your email if you want to leave your email addresses so that we can continue to be in contact with you about news and events at Fletcher. Thank you so much, and without further ado, let me introduce Professor Louis Aucoin.
Thank you very much, Susan, and welcome to you all. So nice to see a full house. As Susan has mentioned, my career is somewhat unique in terms of the fact that I have been both an academician and a practitioner in this field of rule of law. Actually, this field of rule of law promotion has been around for a while, but it still feels like quite a young science, and it's actually still a bit underdeveloped and needs definition and and promotion, obviously. And this is one of the reasons why, or the main reason why I teach, because I really hope to, every year as I'm working with my students, I think about sending out a new generation of people to go around the world and work on the development of the rule of law, and there are so many places in the world, as we know, that need that kind of support. So this is, as I say, why I teach, and at the Fletcher School I teach comparative law, transitional justice, and a seminar which I call Rule of Law in Post-Conflict Societies. As the academic director of the program, I work closely with students in advising them in the development of their career and in the pursuit of their academic career while they're at Fletcher. So I just wanted to briefly introduce myself to you this morning, and I want you to know that I would certainly be available for any questions that you might have about our course offerings at Fletcher, about the development of my own career, if that's of interest to you, or anything else. Thank you very much.
So I now have the pleasure to introduce to you Mr. Quang Trinh, Senior Associate Kang and Wood Mallisons, and also Mr. Derek Wong, your Compromis Authors for 2013. Let's give them a good hand. Now, I know these gentlemen have caused many long and sleepless nights. So you now have approximately an hour or so to go ahead and ask them all the questions that you've always wanted to ask, and also feel free, because I've been told that they're going to be willing to take you on with any particular issues. So I welcome you to approach the podium, and also I will let the gentlemen have a few words of introduction as well. Thank you very much.
My name's Quang Trinh. I think I've actually judged a few of you in the preliminary rounds, and I'm a senior associate at King and Wood Mallisons, but the area of law I'm particularly interested in is not corporate commercial litigation and insolvency, which is what I practice in, but it's public international law. It's just difficult to find quality jobs in that field which give you not only the fun of practicing public international law, but also enough to pay off a mortgage. So that's why I'm doing what I'm doing, but by all means, pursue your passion rather than pursuing a paycheck. That is my recommendation. I drafted the Compromis with Derek because I know that it's always a difficult balance from year to year to explore cutting-edge issues which are a little different each year, which sort of explore a balance of the law on each side. But I think we had some particular inspirations for this year's Compromis, which we can discuss a little later on, which were just perfectly timed for when Derek and I were interested in developing a Compromis, and we were very lucky that our proposal was selected last year for this year's competition. I think the exercise of developing a Compromis, which I've done once before in 2005, perhaps a little less successfully than this year, it teaches you a lot about what it is that's achievable in the Jessup, what can be enjoyable and what can't be, and I hope that on balance you found the Compromis enjoyable. So I look forward to having a discussion with you about whatever you liked or didn't like about the Compromis.
Hi, my name's Derek Wong, and I believe that it's reasonably customary to start this sort of luncheon with both a thank you and an apology. So for all of you that stayed up till 3 a.m. or 5 a.m. or didn't really sleep at all, well done for getting this far, and well done for being in DC, and thank you for bringing our problem alive, if I can put it that way. Interestingly, I also worked with Quang at King and Wood Mallisons. I've been there for a shorter period of time, so I was there between 2011 to 2012. I'm now currently doing a Master of Laws at Cambridge on the very question of statehood, or certainly my dissertation is on the same issue of the position of island states that are slowly becoming inundated with water. That is not to say I take full responsibility for any of the problems that have that you may have with that particular issue, but certainly I feel your pain, if I can put it that way. I competed in the Jessup in 2008, in the days where a lot of people died in the Moot problem and it was all about use of force. I think coming from a different perspective now, I've now coached it, and now being a Compromis author, it's quite a different experience. But it certainly made me miss mooting, it's made me miss international law more, and I often say every time I come in contact with international law through the Jessup, I have more and more faith with it. And so I too look forward to a discussion, or what some may call a grilling, about particular issues. But you know, for everyone that's done the Jessup, we all know we are slightly masochistic in that respect, or we wouldn't be doing the Jessup. So, you know, we'd be delighted to have this conversation, and thank you for all showing up.
We have about an hour and 15 minutes, so we really want to encourage you, as those of you who have been here in years past know that the line can actually get quite long. I want to encourage you to come to the mics to ask your questions. Please feel free and don't be shy.
I wanted to know what the population of Rhodesia was and why it wasn't mentioned in the Compromis.
I think there may be some political ramifications if we suggest what Rhodesia was modelled on. So let me just say that the idea was that it didn't matter if you were talking about a large, developed, sort of Western or developed nation, because ultimately it doesn't matter how many people they have, they're still kind of bad guys, so that's all that matters.
I respectfully disagree, but okay. Okay, so my second question was, were there any Alfrenan migrants released? The Compromis was silent on that, and it seemed to really matter during our arguments. And why was it silent?
The inference we wanted everyone to have was that no one was released. And we were silent on it because it wouldn't add anything to say no one had been released. But we wanted to say that no one had been released, but there are philosophical differences between people who assist in the review process about the point of saying certain things. And we could either say no one's been released, or we could say nothing, and either way you had to assume no one had been released.
I think, if I may say so, we also adopted an approach where we realised that the Jessup problem every year has a lot in it. Obviously, there's a lot to say, both in your memorial and in the oral submissions, so we felt that there were issues or things that we deliberately left out, or we deliberately stayed silent on, so as not to generate problem after problem after problem, so that the Compromis became completely unwieldy, particularly when you got to the oral rounds, where rather inquisitive judges may push you so far that you just run out of time to say anything on your second prayer.
Thank you so much, and go Rhodesia.
Good afternoon, Your Excellencies. May it please this bench. My name is Hamid bin Salama. Okay. A small question. Is this based on a true story? Is this like, as we know that Maldives is they say in 5 years ahead it will gonna be submerged, I guess so. So is this based on a true story?
The inspiration certainly comes from the position, to address your statehood question and the factual scenario, the inspiration certainly came from quite a few small island nations. Speaking for myself, I used to be at the University of New South Wales as an undergraduate, and I was taught public international law by Professor Jane McAdam, who I'm sure some of you may be slightly more familiar with than others. And I was also Rosemary Rayfuse's research assistant for a couple of months, I think, on that actual question of freezing maritime baselines. And so the Maldives, Tuvalu, Kiribati, and so on, was the sort of underlying factual scenario for that particular part. The migration issues were things that we wanted to explore, again, through being from a certain area of the world where things were happening in that respect. And the banking issue was an issue that we thought was reasonably contemporary given Europe and given the financial crises that exist throughout the world today.
In terms of a direct inspiration, the starting point wasn't the statehood stuff. The starting point was really what has become the transfer to Sadie idea. And as many of you who have done research on it will know, there is a very similar problem, although it's really a problem of domestic law for Australia in its arrangements or proposed arrangements with Malaysia. The inspiration behind using that was that all the discussion about it was political primarily, and it was about Australian domestic law and whether what they were doing was legal. I was interested in whether there were strong international law issues to explore with that arrangement, and then once we talked about that and added on Derek's idea of statehood, the first three prayers for relief sort of wrote themselves, and then the sovereign debt crisis sort of gave inspiration for the fourth issue. But there is no single real-life scenario that has inspired the entire problem.
Thank you. Go Alfrona.
Okay. So those of us who have seen past compromis are more used to prayers for relief, which clearly define the issues in each, issue. And I'm just curious because my team never quite figured out what the difference between issue 2 and issue 3 is. So I'm curious as to what you thought, where you thought the line was, and what you expected us to argue in each submission. Also, Alfrena forever.
This is one of the questions that Quang and I, in verbal feedback, tend to call anticipating the question.
You won't be surprised to know that some very experienced friends of the Jessup have also asked that question, and some judges perhaps are a little unclear themselves about where the dividing line is. For my part, I thought it was always crystal clear that prayer 2 was about diplomatic protection or unclean hands as the standing or jurisdictional point, or admissibility point, I should say. And the second point, the wording of the prayer talks about processing and according status. Those words were chosen very carefully to delineate the difference between what you were supposed to cover in 2 and what we were supposed to cover in 3. Prayer 2 was not supposed to be about arbitrary detention. It was about whether or not there were rules of international law that required you to take people who are migrants, who entered your shores legally or illegally, and then do something about their visa status or their right to be admitted into your country. Prayer 3 was all about arbitrary detention and treatment conditions in the detention centre, and I thought that was crystal clear.
Thank you.
So the compromis mentions certain things about the Credentials Committee, the Secretary General waiting for the court's opinion, and the court obviously being seized prior in time, and none of the other organs of the United Nations have considered this question. Could you maybe reflect on that and whether you were expecting any form of arguments on the politicalness of the issue or a political question, so to speak?
I think we deliberately left open the question of what the Credentials Committee, the Security Council, the General Assembly, the Secretary General had done, for the simple reason that we weren't intending to raise any questions of, for the lack of a better expression, judicial review. That is, we weren't intending to raise the relationship between the ICJ and the various other organs of the United Nations. As to whether we expected arguments, I think we deliberately made it we tried to make it a more subsidiary issue. I think we would have expected, or we did indeed expect, teams to come up with something to say about it, but perhaps not to lead with that particular point. How that played out, I think it played out certainly in the moots I saw in the way we reasonably thought would happen, and we were quite happy with the way that teams dealt with that issue, speaking for myself in the moots I saw.
I think the thing that may not be obvious from the compromis drafting just by reading it is that the process involves not only thinking about the legal issues and the balance of the facts on each side and balance of the law, but the review committee's function is to look at what the authors have produced and ask themselves, is the story something that makes sense? Have you covered off the sorts of things people might do in real life, whether or not it has legal significance or not? How do you package the facts? And I think there was a feeling that it would be unlikely for the UN to simply be quiet about what was going on. There was bound to be some sort of discussion, and it was difficult to craft that in a way which had no legal significance whatsoever. And so ultimately, whether you read some legal significance from that postponing of a decision was up to the students. I have seen a couple of memorials that have dealt with the jurisdictional issue that arises from that. I would say the answer is not clear about what that would do to jurisdiction. So.
Thank you.
Can we also just say, for those that, I'm not sure how familiar with certain people are with the drafting process and the function of the review committee and the compromis authors, what happens is there's a bid process and the compromis authors submit sort of an initial draft which gets reviewed and moderated, and changes are made throughout the year until the compromis is released. So there is an additional layer of people superimposed onto the compromis authors and onto the compromis that make suggestions about what should change, both in a substantive sense and in a narrative sense. So what you see is actually the result of Quang and I's initial draft, comments made by a very dedicated group of people who we pay tribute for, both in making changes in the narrative and in sort of certain substantial issues. And then we tended to incorporate and redraft. So just to be clear about what the process is.
Thank you.
Good morning. Firstly, I feel very, very awkward considering that one of my first judges was actually the author of the compromis, and now I feel embarrassed for, citing it. But my question is regarding what is the relevance of the Nullitry Cove villagers? Honestly, up to today, I have no idea. And secondly, I would like to know, what do you, the authors of the compromis, consider to be the biggest red herring presented in the compromis, as in that little detail that you purposefully put in there so that we'll wreck ourselves trying to find the significance for over 2 months? And, well, that's my question. Thank you.
To answer quickly your second question, that would be refugee law, certainly from my perspective.
In terms of the first question about the Nullitry Cove villages, the origin of that idea was that the original structure of the Waroma Detention Centre was that there were several blocks that were distinct. They had different treatment conditions. One was going to be a good block, one was going to be a terrible block, and the middle one was going to be perhaps some combination of the two aspects in some way. And we had originally thought we could test the idea of equal treatment of the same group of migrants. Now, in a narrative sense, or in terms of a storytelling sense, you had to ask yourself the question, how do we get a distinct group of these Alfernan migrants into one block versus another block? How could you also clarify that in a particular block there were nothing but Alfernan migrants, whereas in other blocks it's unclear whether there were other migrants or not? That leads to issues about diplomatic protection, because obviously Alferna cannot be complaining about the rights and harm done to non-Alfernans. So to the extent that it was clear that one block had nothing but Alfernans, you could at least have very clear diplomatic protection rights to espouse for them. So whether you argued about the other bloc, it sort of didn't matter for most purposes. And the clearest way we could think of having a particular group of people who are all Althurnans in one block was to have an identifiable indigenous group or social group, and the Nullatory Co-villages was that device. So that is the process of thinking that led to having them. In terms of your second question about the biggest red herring, I think mentioning the Refugee Convention was the biggest red herring because it was never expected that people would try to argue that that convention applies as a convention. It was intended to inspire thinking about what refugee law is. And it's a big red herring for me because it then led to lots of substantive argument that applied the convention. And yeah, so that's our view on that, I think.
Thank you very much.
Great. I just actually want to ask a quick question from the web because we do have a number of questions in there. So I do want to give a voice to those who could not be in the room today. So we do have a couple of questions. Let me just start with one. And this question is actually of an opinion for the Compromis authors. So the question that was raised here is, in the opinion of the Compromis authors, are the criteria for statehood under the Montevideo Convention still relevant to contemporary international law?
The short answer is yes. The long answer is my thesis is due in 3 weeks. The answer, I think, is this. Obviously, for those that were working on Prayer 1, and certainly for all of you generally, the Montevideo Convention represents what is traditionally accepted as the minimum requirements for the creation of states. The distinct question, and I notice there are motions in front of me, is to strong agreement in that respect. The notion that the Montevideo Convention is applicable to the extinction of states or when a state ceases to exist is a separate question. That was never raised in the during the drafting process of the Montevideo Convention. There is a logical attraction to it. Certainly, it doesn't make sense if a state requires certain things to exist. It can sort of continue to exist without meeting those requirements. But that having been said, one of the issues that we certainly grappled with during the drafting process, particularly the drafting process for the bench memorandum, and also for myself when I was dealing with this particular issue, is surely international law doesn't tolerate a system where an entity ceases to exist or a state ceases to exist at an uncertain point in time where as soon as the first wave crashes over the last rock, that's it. The state ceases to exist. Everyone becomes stateless. It loses all its maritime rights. It loses all the obligations that are owed to it and the obligations it owes to other people and its people.
Probably the one other thing I would add to the question of whether the Montevideo Convention criteria are relevant is that, yes, they are relevant as a starting point for the discussion, because it would be very difficult for anyone to throw it away and say we start again with some random set of criteria or principles based on the writings of various scholars. Because the Montevideo Convention provides a starting point, and then you can debate how much or how little of the Montevideo Convention criteria are necessary to answer the question, is an entity a state?
Well, the Compromis talks a lot about climate change and particularly Rutetia's contribution in terms of carbon emissions and the acts of its private company. Now, was it part of just the unclean hands characterizations of Rutetia's act? And if at all it was, where did you see its significance? And my second question is, was there a contradiction, an apparent contradiction that you wanted us to figure out between the first issue and the fourth issue in terms of a state seizing an asset of another state which it did not see as being still in existence. So,
on the climate change issues, they served two functions. One was it provided the setting for the climate change loan. It provided a starting point for understanding why the states behaved the way they did in respect of taking a climate change loan or giving it, because from a storytelling point of view, you need to understand those actions, and in the absence of participation in the climate change framework, it just seemed very, very random that these things would happen. Secondly, in terms of legal significance, our original intent, and I think that has played through to the final drafting of Compromis, was that the climate change convention was one avenue for arguing unclean hands. It was what we thought was the weaker argument, because in order to succeed on the classical view of unclean hands, if it applies as a doctrine, you need to look at causation. And it's not a red herring in the sense of the whole thing not being relevant at all, but it's a red herring to the extent that it sucked teams in to arguing causation of climate change, because as you all know from reading the climate change deniers and those who say that the climate change causation is clear, it is debatable. And for you to establish causation on these facts, it would be very difficult. And what we wanted the MCL fact to provide was perhaps, if you argued it well, a more plausible argument that Rutasia's conduct contributed or caused the particular harm that Alferna has suffered. So that is the many functions that we wanted those facts to serve.
As to your question on prayers 1 and 4 and whether there was a contradiction, I think the thing we should say about that is we deliberately designed the Jessup problem such that there were inconsistencies in the position of a particular state, or throughout the Alferna position and indeed the Rutasian position. So yes, the intention is for teams to sort out how they can put one argument and how that argument relates to another argument that a particular speaker, him or herself, may make internally and also across speakers. So the idea was we needed teams to think strategically about how the arguments interrelated and whether they contradicted themselves, and whether, if they did, how they were to explain it away to a bench that picked them up on that issue.
But ultimately, the simple answer to the inconsistency point is prayer 1 is about jurisdiction. That jurisdictional argument is premised on you arguing that Alferna is not a state. In order to get to prayer 4, unless you think up a clever way for the court to still have jurisdiction even though Alferna is not a state, the assumption is to get there, Alferna still is a state. And the better prepared teams made the assumption, and they argued it in the alternative, so that the relationship was clear in terms of the factual grounding.
Good afternoon. First of all, I would like to congratulate the authors on what I think was an intriguing problem this year, and a particularly relevant one. I have 2 questions relating to the matter of statehood. Firstly, I note that paragraph 31 of the Compromis speaks to the initialing of the draft agreement. I was wondering if the authors had contemplated assigning a lot more legal import to that agreement, that draft, on the basis alone of the initialing. I don't know if it was to import Article 12, I think it is, of the Vienna Conventional Law of Treaties. Secondly, in the run-up to the competition, a lot was said about the loss of territory, but I was wondering if there were any facts which made the matter of capacity to enter into legal relations a relevant issue and a live issue in the Compromis this year.
If I can deal first with your second question about the capacity to enter into relations with other states, that's one of the issues, or certainly one of the criteria of the Montevideo Convention that is heavily criticised. And I'm sure all of you would have read Professor Crawford's book in terms of how much time that is devoted to that particular issue. The way I see it is it's really a question of independence. So there are two broad ways or broad criteria for statehood. The first is the existence of a territorial population governed by some sort of entity. So the first three requirements of the Montevideo Convention, and the second is independence. There is actually, in my view, quite a viable argument that an entity that purchases or leases land from another state and positions itself on that territory can never, or it's debatable whether that entity could ever satisfy the requirement of independence, because that requirement may be interpreted as whether an entity derives its legal legitimacy from international law directly or from the consent of another state, in this case Finu Tafu. So there is an argument to say that states in Alferna's position, or when the Maldives thought about purchasing land from India or Australia, whether it is possible for states like Alferna or the Maldives to remain independent because they exist or they sit on the land of another state effectively at the consent of that particular state, and therefore it's impossible for them, on this line of reasoning, for them ever to be truly independent. As to the question of the lease, or the question about the initialing, again, speaking for myself, my view about the lease and the private purchase of territory changed quite a lot from when we first drafted the Compromis to when the Compromis was finally published. I think when we first started, both Quang and I were in strong agreement that the lease or the purchase of territory may or may not have been the strongest argument to ground the existence of the state and the continuation of the state. Personally, I've changed my view slightly, and I think that it doesn't actually matter. The strongest argument doesn't relate to the lease at all. I don't think that the purchase of the territory, short of the full cession of territory, but the purchase of territory or the lease of territory probably is not enough to keep a state alive if that's the only argument you've got.
On the question of the significance of the original draft agreement, for those of you who've done the research, you'll know that that draft is based heavily on the Treaty of Nanking for Hong Kong. And the reason why we wanted to put that in there was to provide a starting point for your research on how many examples have there been where people have given away a piece of land with full sovereignty over it being given away as well. And that contrasts with what happened eventually, which was the lease. Now, both teams can play with the significance in that contrast, but obviously I think that the clearer inference is one is lesser in intent in terms of what was given compared to the other one. And that must have some significance for assessing the relationship between the two states. But in terms of strict legal significance of the draft agreement, no, we didn't expect anyone to say that it was somehow binding or anything like that. In terms of the question of, the second question about the relevance of the lease, I think I take a slightly different view of how you would argue the Montevideo criteria, and I think if you took a very narrow view as an oralist, you would say, look, let me make this simple for the court. I'm looking at 4 criteria. The biggest contest between the parties is about the territory. What does territory mean? Let's talk about the lease. Let's talk about owned land and what that means conceptually. You can talk about capacity to enter into legal relations, but you try to downplay that. And there are facts in the Compromis which allow you, if you choose, to spend a lot of time on capacity to talk about it, but I don't think it necessarily takes you anywhere, because probably the better view is the criteria don't exist in isolation from each other. They are more flavours or elements of essentially one complete package about what a state is. So capacity to enter into legal relations, I wouldn't have dwelt too much on that in and of itself, but there is material there for you to explore that in terms of UN membership, in terms of entering into the lease itself at a particular time, and a couple of other things in terms of the way Alferna deals with the outside world. And I think a good team would have been able to shut that down and keep it very, very narrow rather than spending a lot of time debating it.
Thank you very much.
And my first question is on behalf of the Alferna government, because Alferna, in the Compromis it says that Alferna government enable but all the 3,000 migrants and left them on the island. So I'm curious about the ability. So first I read the sentence, I thought it's beyond Alferna government's ability to transfer all those citizens, but the judges keep asking me the question, okay, the only reason that they left those people on the island is because they refused, some of them, about 1,500 refused. So I guess you know the reason why those people has been left on the island. It is the only reason that refused to do so, or it's because, or the Alferna government has done everything they could do. Thank you.
All the people who were left behind obviously to create the legal issue that arises from them then migrating to Rhodesia, but the leaving of them behind also contributes to unclean hands. Yeah. And the question is, how much of that do you complain about if you're going to argue unclean hands on abandonment and so on? Now, for those who were left behind because they refused to participate, that is intended to provide a less onerous obligation on Alferna to do something to save them, because what can you do? I mean, a question was asked a question asked in many rounds was, did you expect to tie them up and take them by force? I mean, that's absurd, but some people said yes. That is, what the government should have done. Obviously, if you thought about that answer, you would know you shouldn't give that answer. The second thing is the people who didn't qualify for the migration programs, and we only said some of them didn't for various reasons like moral character or criminal records, and that is an interesting point because if they didn't qualify for migration programs, it's arguable that Alferna should have tried harder to find some alternative to help them out. But then the people we don't talk about, that's a narrative issue. That's a story issue because realistically, given the circumstances, you've got 3,000 people. You can't know the story of every single one of them. The only time anyone would know from a story point of view is once they landed in Rhodesia, and then some of them will tell you the truth, some of them will lie. And so the question is there, realistically, could you know why every single one of them did not migrate? And the answer is no, you couldn't. So we had to stay silent on some people from a story point of view. And you just have to say, I don't know why they stayed behind. And then Rhodesia has to say, well, they could have done something more, but then you ask how? We don't know why they stayed behind.
All right.
We don't know whether they got lost or something, so,
Okay, thank you. And my second question is about, my second question is about the last sentence of the 33 paragraph of the Compromis. It says, okay, Burma Center is the only facility of its own type maintained by the Rhodesia government. So I wonder, of its type, it's reasonable to infer that of its type means that it is the detention center and Rhodesia may have more alternatives like maybe a American school. I know in the fifth paragraph of the clarification, I have been proved that. But the first time I read the sentence, I saw of its type, I imagined that Rhodesia may, as a large, very developed country, have an alternative, just like maybe a American school or something facility. Do you think it's reasonable to infer that? And do you think that kind of imagination is good or maybe do bad for the understanding of the Compromis? Thank you.
From my recollection of the drafting of that, the only intent behind saying it was the only facility of its type was to mean it was the only immigration detention / processing facility that was available. And that then leaves available to you an argument that surely if you wanted to be nice as Rhodesia, you could put them into a hotel or into a nice school that doesn't have asbestos in it, or things like that. And then it becomes a question of how reasonable is it to ask Rutasia to do that with migrants who it otherwise has discretion over how to process.
Thank you very much.
I am very impressed by the extensive grasp of all the legal issues you must have as the authors. And nevertheless, I'm really wondering, were there any issues you were surprised with? So did teams manage to come up with arguments or problems that you as authors did not anticipate? And second small question, what was the thinking behind the disentitlement part of the fourth prayer for relief?
There were differing levels of expectations in terms of what we were surprised by. One team spoke to me after I judged them, and one of them said to me that they were very excited. There were two types of dysentery, and I'm sorry to bring this up during lunch. I think we thought about that, and certainly some of the review committee did, but I personally was quite surprised that that was a submission made. I'm not suggesting it wasn't viable. I just think that was something that I hadn't necessarily expected as one of the primary arguments for that particular issue. I don't know what else you were surprised by.
I think that the Compromis has mostly, I mean, this is very rare, I suppose, but it's, the Compromis has been argued and analysed predominantly in the way we expected. There are only marginal topics that are very detailed, very fine arguments that fall outside of our strict expectation. And I think that the one thing that comes to my mind is a very specific argument about the clash between the UN organs looking at UN membership and the jurisdiction of the court in deciding a similar issue. We had looked at the jurisdictional issue in a very particular way, and we didn't expect the political question point to really be alive on the facts, because the facts were designed for different purposes. And yet I saw in a couple of memorials a very detailed argument on whether this sort of case under the court's statute should have been an advisory proceeding, since the UN organs are supposed to think about UN membership. The Secretary-General deferred the decision until the ICJ had made its decision, and that sounds potentially like a request for an advisory opinion. Whether that's right or not, I'm not sure, but I would say that was something we hadn't thought about.
I should say there's one addition. I saw, not in the international rounds, but I witnessed a practice moot, which on the fourth prayer ran an argument on territorial debt. That is that debts, and this is actually, this comes from the context of state succession, but they ran this argument by analogy, which was there are certain obligations at international law that exist only in relation to a particular territory, and because Alferna had moved its territory to a different area, Nusa Island, then that debt became extinguished. Moving on to your other question about Prayer 4 and disentitling conduct, our primary consideration was to test clean hands in two prayers so that students were forced to think about consistency between the pleadings in prayers 2 and 4. So, for example, if a particular team argued that the doctrine of clean hands did not exist, it would have been precluded from arguing the clean hands doctrine for the other prayer that they were seeking to put that in support of.
The disentitling language was difficult to decide on, because although our original intent was to explore the operation of unclean hands, based on the sort of material you could use to argue the appropriateness of the debt, the good faith nature of lending to a state that could never repay, those issues can create an impression that you should argue different things to unclean hands to avoid responsibility. Technically, it was really about unclean hands. That's what that word is supposed to allude to. But obviously a lot of students saw that as dealing with other issues, and that was legitimate given what the law is. It's just that wasn't our intent with using that word.
Before I ask my question, I just want to echo the sentiment around the room to thank you for this compromise. We've really enjoyed learning about these areas of law and working through this problem. My question is about the vexing issue of the loan. We've seen a lot of different arguments from different teams on what to argue on prayer D, necessity, force majeure, fundamental change of circumstances. Every team's come to a different opinion of what the correct argument is. What, in your view, is the way to go about prayer D?
Well, I should probably start by saying that the inspiration for that prayer was an observation that in the case of sovereign to sovereign debt, and if you look at the behaviour of the Paris Club in particular, it's a very strange thing to observe that frequently what happens is money is lent for whatever purpose, then it is not repaid, and then more is lent, or the debt is cancelled in large part or entirely on a repetitive basis. And the question that arises with that is, why? Is it entirely a political decision, a political discretion thing? Is it because the purposes of the loan are not traditional lending purposes where you expect repayment, but the strategic, tactical, geopolitical decisions, so you never care about getting the money back, you just want to lend to these people to maybe get their allegiance and so on. So all of that is non-legal. But if you look at legal reasons why it might be so, the simplistic analysis would be there's somehow developed custom that you can't enforce in some way. And that is the simplistic answer because it is not supported by the practice or opinio juris. And so the question is, where do you go if you're arguing that when you know from a close analysis of custom, conventions and so on, that there aren't obvious rules that apply, so you fall back on secondary rules or secondary concepts like immunity, like necessity or force majeure, circumstances precluding wrongfulness. I think one team that may not be here, but it was in the US regionals, thought about, if not argued, countermeasures, and that the behaviour of the enforcing state was effectively a countermeasure. There are a range of arguments that are based on classical, well-understood concepts of international law and international rules, which are more orthodox and more applicable, and then you can argue about whether they are at the margin of what is necessary to establish the requirements for those defences or those circumstances precluding wrongfulness, and also the immunity point. But obviously it was open to everyone to argue things like, well, there are rules about lending to states that can't repay, there are good faith or fiduciary duty obligations that arise from that. It's open to you, it's just not necessarily the strongest stuff that's available.
Thank you.
I wanted to extend a thank you as well to you and all the judges for your time, to the Jessup. We've had a fantastic season this year, I think. And he actually asked the question I was primarily going to ask. So I guess I will fine-tune my question in that we were wondering, my team did make an argument that there was a custom, even though we knew in reality regarding the opinio juris element as opposed to comedy, regarding the Paris Club and all the different lending practices that didn't fly. So as judges, as writers of the compromis, when you get those hard issues, do you expect the competitors to make those hard, almost unrealistic arguments, such as environmental refugees, which if you truly look, is there opinio juris relating to granting of environmental refugee status? Probably not. So as judges, as writers of the compromis, do you think that it's prudent of the competitors to make those arguments to show that they've seen the issue there and they're being creative? Or do you think it's smarter of them to say, well, opinion jurist really doesn't exist here, so I shouldn't waste my time?
On different sides of the problem, obviously, on the side denying the rule, it's easy enough to say there's no consistent and uniform state practice, or there's no opinio juris, and usually it'll be the opinio juris that kills or tries to kill the other side. But on the side that has to establish the rule, I think most judges here understand that there is a challenge to establishing custom. I mean, the standard is quite high. And the question isn't so much, should you run the argument? It's that there are different parts of the problem where it is more plausible, even though probably ultimately, objectively, you can't succeed. But certain parts of the compromis allow a more plausible argument on custom, even though really it's an emerging practice, an emerging custom, or something based on political expediency. And I think that the question is, do you make the right judgments about which battles to fight? And sometimes the battles that were chosen were impossible battles, and people made wrong tactical decisions in terms of spending time pursuing arguments that just really couldn't fly, as you say. But you know what, on the Paris Club stuff, it's a very sophisticated argument that understands that actually you could take Paris Club and argue, if you look at how frequently they behave the way they do, how consistently they behave the way they do, strictly speaking, the requirement in North Sea continental shelf to have evidence of opinio juris is perhaps overstated or overemphasized in a scenario where the practice is so consistent, so repetitive. And there's an ILA paper on the formation of custom which explores the true role of opinio juris and when you really need to prove it. I didn't expect most people to find that paper and analyse it, but it's possible to explore what the consistency of Paris Club practice really means for this area of law. And you can have the conversation. Most people aren't able to have that conversation, either in terms of understanding the strict limits of North Sea continental shelf or understanding how they would use that ILA analysis of custom.
Can I just add two things? The first is, there's a great decision that I'm sure most of you have read, the Germany-Italy immunities decision that came out quite recently from the ICJ, which for one of the first times deals in great detail with what exactly is state practice and what exactly is opinio juris and how does it work. We were quite keen on exploring, particularly when we first drafted the compromis, on thinking about what opinio juris really was and how that worked in relation to the Paris Club. Tied in to that particular point or that particular proposition was the second point I wanted to make, which was what I largely call concepts of international law. So I found that a lot of the ways that one can answer very difficult questions of international law, particularly when one is asserting a new customary norm or interpreting a customary norm in a particular way, so for example, questions of statehood and territory, or indeed questions of sovereign debt, was how or why does a particular rule exist? So that statehood question is the obvious one. Why are states primarily territorial entities, and why do we insist on sovereign control or sovereignty over territory or true independence over territory before a state can come into existence, and how does that work in terms of continuation? So teams that sort of asserted that there was a presumption of continuity or asserted that there was no opinio juris in relation to the Paris Club without explaining why often suffered when they got to the harder points and benches were inquisitive about, well, why does this rule exist? What is the rationale behind this rule, and how does it relate with the other concepts of international law when international law is about the creation of stability between states, or at least that is one of the functions of international law.
Okay, thank you.
I have two questions regarding inferences from the compromis that my team and I kind of went back and forth on a little bit. First, it states that currently on Nasatima Island, there are 3 government agencies there, with the rest planned to be there by the end of 2013, I think. But it's quiet on whether anyone's actually living on Nasatima Island or if anyone's working in those agencies. So is Nasatima Island inhabitable? And second, upon being transferred to Camp Sontag, the Nellitree Cove detainees held on Block B, it said they were going to be transferred into pre-existing detention facilities. Were they going to be forcefully integrated into the general population at Camp Sontag?
In terms of the ministries having been moved to Nasatima Island, I would struggle with anyone who suggested that there was no inference that people lived there or were there sufficiently for the permanence criterion of the Montevideo criteria, because if the ministries have moved there, what does that mean? Unless we've been specific that all that happened was that buildings were built there and furniture was moved there, it would be difficult to simply say there aren't people, or that there aren't people sufficient for a permanent population. That's my view, but obviously you can argue it. I would struggle with the counter-argument. The second point about Camp Sontag, I think from a storytelling point of view, the reality is these people would be thrown into general population. There's no agreement otherwise, and based on the reality of what Sadie is as a state that arguably has a poor human rights record, I doubt that they would have been, shall we say, considerate in how they treated these people.
Okay. Thank you.
Hi. There were a lot of clarifications and corrections to the compromis this year, and I was wondering what was the major issue that came up after the original compromis was written and then had to be addressed in the clarifications, what your opinion of maybe something that needed significant amendment. And secondly, our team sort of agonised for about a week over the choice of law clarification and whether that was intended simply to shut down the question of whether it was a treaty, whether the loan agreement was a treaty or not, and was that your intention, to simply shut it down or to kind of bring it up as a thing that needed to be addressed?
We need to be very careful here about ascribing responsibility for the corrections and clarifications, because there are some process issues that explain some of that. But in terms of the biggest thing that needed clarification, I think there was a tremendous concern once the original compromis was drafted about whether the transfer to Sadie topic was sufficiently ripe for argument based on what we had put into the main body of the compromis. And so the biggest fix that the review committee thought was necessary was to provide more evidence that there was substantial ground, or there were substantial grounds for considering there was a real risk that the migrants would be harmed if they were transferred. And I think from memory, in terms of all the discussions through the drafting of the compromis and then the clarifications, that was the biggest concern, because originally we conceived of the transfer to Sadie issue as a question about whether the outsourcing of immigration processing obligations was in and of itself per se a breach of a state's duties to migrants under international law. And then as the thinking evolved on that, it was really about the substantiality of the risk that the migrants would be harmed. And once that became the focus of the legal issue, then the question about evidence came into play. And that was the biggest issue there. In terms of the choice of law clause, the intent of the clarification was to rule out the confusion about whether we were dealing with a treaty. And in terms of reflecting real life loan agreements in this sort of scenario, that's why that was put in there. The fact that it then gave rise to complex questions about what that did to the relevant rules of state responsibility and circumstances precluding wrongfulness, interpretation of the breach clauses or the default clauses, those were unexpected issues that flowed from perhaps focusing too much on one clarification problem.
Thank you.
All right, since it's come up before I ask my question, I'd just like to thank you on behalf of my team and our learned colleagues also from the South for the opportunity to argue that leaving 3,000 people behind is a perfectly okay thing to do in front of judges in New Orleans. But beyond that...
An absolute pleasure. You're welcome.
But beyond that, in my first regional round in New Orleans, probably the biggest and most important legal instrument that came up was the United Nations Convention on the Law of the Sea. And I'm curious as to whether you anticipated that to be a document that teams were relying on heavily, and if so, why are the parties not explicitly parties to the UNCLOS?
I think I can speak for both of us when we say we deliberately tried to omit the UN Convention on the Law of the Sea arising substantively on the issues. Questions, certainly in relation to why there were certain basic materials that were released that sort of dealt with maritime rights, the arguments that Professor Rayfuse raises in relation to freezing maritime boundaries. That particular article related more to questions about the deterritorialized state than the actual UNCLOS rules. The application of UNCLOS, to the extent that you bothered to look at it and argue it, was really about, whether it helped you figure out whether these people were illegally in the territory of Rutasia or in territorial waters. But ultimately, my analysis of that is it doesn't matter whether they're illegally in your territory or not, because ultimately the true or core issues are how you treat these people regardless of whether they're criminals or not. And the reason why we deliberately avoided UNCLOS issues is that in drafting the 2005 Compromis, I and my co-author that year found that the more you pick away at UNCLOS, the more you find you don't know how UNCLOS works, and the more you have to keep on researching and researching and researching, and it never ends. It never ends. And so we were desperate to avoid that this year. I should add, there is, I don't know if this is what you're trying to get at, there is some argument that I saw that UNCLOS determines the definition of territory, that is an uninhabitable rock. I think it's Article 121 of UNCLOS that deals with whether a rock that is uninhabitable can carry the status of an island and so on and so forth. To the extent that that requires UNCLOS, the court earlier this year, Nicaragua, Colombia, dealt with that issue, and dealt with it under customary international law, so UNCLOS just isn't required in that respect.
Good afternoon. I have two questions. First, regarding the fourth claim about the seizure of money, there is an issue that comes up in the 2008 France Djibouti and also the 1986 Nicaragua case regarding self-judging clause, that the Rutasia can, at its election, seize the funds. And as far as our understanding, this would preclude the jurisdiction of the court, but this was not an issue that was raised in most of the bench memo questions that we heard. And the second question comes up as a question of balance, and I've understood from reading past memorials, Compromis, that usually there is a balance between the sides. However, as an agent for Alfurna, it was very easy to represent my clients against the detention, lack of food, water, the lunch that we eat today, nobody would ever have in Roma, and also the transfer. So I was wondering about the balance between the two parties. Thank you.
In terms of the charging clause issue, it wasn't intended to deal with any of the issues or the cases you were referring to. And the difficulty with that clause is that it creates some difficulties we had not intended to raise. All I can say is that there was a disagreement about whether that clause should go in to the compromis, and we did not agree that it should go in there. But once it went in there, it creates an issue that I did want to discuss with students, but it's conceptually very difficult, which is when you are looking at taking money from a bank account, is that actually a taking of anything? Because money in a bank account is just a debt that the bank owes to the account holder. It is not property in the usual sense that you can seize. And the usual way you deal with the right to take money in a bank is a set-off clause that says I can cancel what I owe you, or I set off what you owe me with what I owe you. And so technically, anyone who understands commercial law and banking and finance law would say the default clause does not apply at all. But that is a conceptual difficulty that was unnecessary for the problem, and so it wasn't explored very much in oral argument. The
question of balance.
The balance issue, initially we were concerned about the balance. The drafting process raised a lot of issues about balance, but you know what, watching the way things have mooted out, watching what students have done with the facts, I think actually the balance isn't too bad, because if you look at the statehood point, the law and the concepts are debatable, genuinely debatable. The migration, prayer 2 is probably more clearly weighted in favour of Rutasia, because the existing law and interpretation of relevant obligations probably doesn't go as far as Alferna needs. But on the treatment of detention, I think whilst the rules may be clear, what you do with the evidence that's available is a really good debate on the law, because you have to argue things like the burden of proof, the sufficiency of evidence, fully conclusive proof. What does Corfu Channel require? What does Diallo require? Is the genocide case relevant in terms of setting the relevant standard of persuasion necessary? And what is the available evidence if Rutasia has all the information and has denied the accuracy of the one report that you can rely on? So I think that debate, if argued well, is really balanced. And then on the sovereign debt issue, I think because it depends how you argue it, whether you argue necessity, force majeure, the immunity stuff, that is also surprisingly quite well balanced. If you start arguing whether there's rules against enforcing debt, or if there are rules against lending too much money to a state that can't repay, you're in trouble, because the balance then is completely against the applicant on that.
Thank you.
I should also say, personally, I agree. I think the balance is actually played out quite well. But I also think I'd also think that the judges certainly felt, or we certainly felt, that arguing Rutasia was certainly not a disadvantage. There's often a great benefit in having what is, at first glance, the harder side. I think if I had to pick which side I was going to argue on the migration issues, certainly not the statehood issue and the banking issue, I would certainly have chosen to argue Rutasia from a personal advocacy perspective. I don't mean from a legal perspective, but I quite enjoy arguing for the side that is sometimes described as the black-hearted weasels of the apocalypse. It's fun coming up with ways to justify or to argue in favour of what is sometimes unfortunate conduct. So the year I did Jessup was the year where torture was an issue, and the other person working on the torture issue with me and I became sort of what we sadly called torture connoisseurs. And it became quite interesting to see how one could justify particular conduct. In this case, deportation, or transferred to another state, detention and under questionable circumstances.
Thank you.
And we're just going to take a couple of more questions. So,
okay. First of all, hi, and thank you for authoring this compromise. I have 3 small questions. First, what do you mean in the second submission of available affirmative steps for Alferno to take? And second, why did you mention the Convention for Worker Migrants when it's not, there is no indication that these migrants are workers in the compromise? And the third question is why you, in the clarifications, you said that the Alferno migrants were relocated in vacant barracks, which is a military base. What is the purpose of this? That's it.
The first question about affirmative steps was designed to facilitate or point to an unclean hands argument, because if you analyse how the unclean hands argument would work in a migration context, if in fact unclean hands applies to exercise of diplomatic protection, and that's an interesting legal question, you would ask yourself, what is it that Alferno has done which has caused the conduct which is complained of on Rutasia's part? Because if you analyse the unclean hands doctrine, the classical conception of it is that the conduct of the complaining state has caused the conduct of the respondent state. And if you have failed to take affirmative steps to protect the migrants such that they end up as migrants sitting in a detention centre in Rutasia, that allows you to sort of say Alferno has contributed to the current predicament. And that's what affirmative steps was about, and there's some law about what your affirmative obligations are to protect your own citizens. The second question was about, sorry, I've forgotten.
Why did you mention in the basic materials?
That paragraph mentioning the conventions that the parties sign up to serves a couple of purposes. Firstly, it gives you the conventions or the treaties that, if both parties are party to that, are instantly binding. That you don't have to argue custom, you just argue the interpretation of the obligations. But the other usual thing that that paragraph is designed to do is that it points you in the direction of material that you might use to argue customary obligation. Now, the Migrant Workers Convention in and of itself and the Refugee Convention in and of itself were not intended to be referred to as binding or directly relevant to these facts. They were intended to facilitate some research into the pattern of migrant protection rights in treaties around the world, and then also an investigation into state practice. And a sophisticated argument about custom would have said, if you look at all of these conventions and if you look at state practice, states tend to feel like they should protect migrants no matter why they are present on their territory. Now, it's not legally a very, very strong argument, but it's the more plausible way of arguing protection rights if you're going to try to analogize with refugees. And the third question was the military barracks. I actually don't know what that was intended to achieve.
Sorry, neither do I.
Thank you.
It wasn't our clarification.
What I should say about the Migrants Convention, the other thing, the way I would have thought about it is this. If you agree, and I certainly do, with Jane McAdam that they're not refugees, the question to my mind was always, what are these people? How can it be that through some lacuna in the law, they are nothing? And so we, when we first drafted the compromise, and when we got to the later stages, thought about, well, what other conventions can we analogize from? And that was certainly Quang's, what Quang was getting at before, and what Quang was mentioning before. So we thought about how can we come up with an argument, or how can you come up with an argument as to what these people are and what rights they have. So the other possibility we could have put in was all the guidelines that have come up quite recently on internally displaced people due to environmental change, but we didn't put that in from memory, just because we thought that was something that you guys would have discovered by yourself as well, and most of you did.
Thank you.
I just have one quick question. Before the compromise came out, there were loads of rumors concerning this being a case involving essentially environmental issues, while at the end of the day, none of the claims directly faces those issues. Why did you decide to develop the case in this way?
You have to remember that when you're trying to summarize a topic into a one-sentence announcement for the post-final announcement of the next year's problem, there are going to be difficulties in capturing just what the problem is going to be about without giving it away. And we had never intended to include environmental claims, because if you look at what climate change is doing to a lot of states, it creates other legal issues, not legal issues about causing or failing to prevent climate change. It creates legal problems with migration. It creates, for sinking states, questions of continuity of statehood. And the sovereign debt thing doesn't come up from the environmental problem per se. But the other three issues are very real issues, or at least the first two issues are very real issues flowing from climate change problems. And then, strictly speaking, those are the consequence. I mean, if you go back to the summary of what the compromis was planned to be about, it is about the consequences of climate change. It is not about rights and obligations regarding climate change. So,
thank you.
Good morning. I represent the Black Weasels of the Apocalypse, and I was wondering two things. Firstly, one is a material question from the compromis. What is the relevance, or what is the weight of Sadie's promise not to torture individuals or not to incur in human rights violations, having had a pattern present or manifest in its entire history? And secondly, what was that argument which you, both of you, having judged various rounds, wished to hear but didn't hear from us, the competitors that were participants?
in terms of the weight of the diplomatic assurance, if you argue it well for Rhodesia, the argument will be something like, if you look at the fact that Sadie and the other parties are members of the United Nations, they're all equally sovereign as an assumption, they are expected to act in good faith. The starting point then is you take diplomatic assurances at face value because there's no evidence to suggest that Sadie is lying about what it plans to do. Then the court is in a very difficult position in second-guessing that. And there are various cases that talk about the nature of unilateral declarations by states and the need to assume good faith in the absence of any evidence otherwise. So on the one side, you argue tremendous weight should be attached to that. On the other side, you argue that the assurance is contingent on being given, on having eased budgetary pressures. And factually, what that means is unclear, because a lot of teams argued, well, what that means is they will promise to do things if they get money, Rhodesia is going to give them money, so that's all fine, and then the counter-argument is, actually, that's not guaranteed at all. And so the weight of that diplomatic assurance is, I think, quite even. And you just need to know how to argue it on each side. It's not sufficient to say there's a diplomatic assurance, that's good enough evidence, and it's not good enough to argue we can't trust Sadie. There are ways you build the argument, and the good arguments are very well balanced.
As to something that I guess I personally wanted to see but didn't, and some teams came quite close to this, is there is an argument at international law on the question on statehood and the extinction of statehood that doesn't start from the Montevideo Convention at all. There is the argument that at international law, and this is the argument made by Sir Ian Brownlee in the 7th edition of the Brownlee text, and indeed it's made all the way through from the first edition back in 1966, is the argument of necessary legal constructs. That is, international law imposes the continuation of a state even though the indicia of statehood have been lost for the purpose of promoting a particular reason as to why the state needs to continue. So, for example, the fact that it cannot be the case that international law tolerates such instability such that all its nationals or a state's nationals become stateless, all its rights and obligations are lost immediately in the 1 second, at that very second that the first wave crashes over the last rock. That argument relies on a conceptual understanding of international law beyond looking at a black letter approach to what is traditionally accepted as the requirements of statehood under the Montevideo Convention, if we can call them that. It required an understanding, I guess, of why international law is how it is, why certain rules exist, and what the purpose of international law was. I think teams came close to that when pushed, but I don't think any team ran that substantively, certainly that I saw, as part of their oral submissions. I'm not suggesting it's the best moot argument to run. It's very hard to demonstrate state practice and opinio juris in a theoretical argument, but it was an argument that I, if anyone brought it, would have been quite keen to have an argument about.
Just finishing my bit of that, I heard all the arguments I wanted to hear, so I wasn't disappointed by the range of arguments that have been heard this week.
Great. And I see that we do still have a number of folks who are at the microphones, but unfortunately we're out of time. I do want to encourage you, if you do want to continue to have dialogue, to connect with the International Law Students Association and continue that forward. In particular, I wanted to thank Leslie Ben of the International Law Students Association. I want to thank our Compromis authors, Quang, Trinh, and Derek Wong, for spending so much time putting together this compromis, and to all of you who have spent a tremendous amount of time and effort and enthusiasm in contesting this year's 2013 Jessup competition problem. I also want to point out once again that we have sign-up sheets for Fletcher if you want to continue to be apprised of information about our program and news about the latest at Fletcher. And I want to encourage all of you to continue mooting, continue being engaged in international law, and we look forward to seeing you in the future. Thank you very much.